Today, an indictment was unsealed, charging Donald J. Trump with felony violations of our national security laws, as well as participating in a conspiracy to obstruct justice. This indictment was voted by a grand jury of citizens in the Southern District of Florida, and I invite everyone to read it in full to understand the scope and the gravity of the crimes charged. The men and women of the United States intelligence community and our armed forces dedicate their lives to protecting our nation and its people. Our laws that protect national defense information are critical to the safety and security of the United States, and they must be enforced. Violations of those laws put our country at risk. Adherence to the rule of law is a bedrock principle of the Department of Justice, and our nation's commitment to the rule of law sets an example for the world. We have one set of laws in this country, and they apply to everyone. Applying those laws, collecting facts, that's what determines the outcome of an investigation. Nothing more and nothing less.
All right, friends, welcome back to Dr. John Podcast family. Special Counsel Jack Smith has filed a court document demanding Trump's sworn testimony, systematically dismantling his immunity claims and characterizing his conduct as an unprecedented criminal effort to subvert the 2020 election. The filing, devastating in its evidentiary precision and comprehensive scope, has fundamentally altered Trump's legal exposure and delivered the moment his legal team has been dreading since Smith was appointed. Trump believed he had escaped the legal wilderness when he returned to the White House. Trump convinced himself that the special counsel would simply fade away, that the investigations would evaporate, that the courts would lose interest in holding him accountable. Trump even went so far as to publicly vow that he would fire Smith the moment he reclaimed the presidency, treating the special counsel as nothing more than a political inconvenience to be removed at will. But Smith has proven to be far more formidable than Trump.
The prosecutors in my office are among the most talented and experienced in the Department of Justice. They have investigated this case hewing to the highest ethical standards, and they will continue to do so as this case proceeds. It's very important for me to note that the defendants in this case must be presumed innocent until proven guilty beyond a reasonable doubt in a court of law. To that end, my office will seek a speedy trial in this matter, consistent with the public interest and the rights of the accused. We very much look forward to presenting our case to a jury of citizens in the Southern District of Florida. In conclusion, I would like to thank the dedicated public servants of the Federal Bureau of Investigation, with whom my office is conducting this investigation and who work tirelessly every day upholding the rule of law in our country. I'm deeply proud to stand shoulder to shoulder with them. Thank you very much.
Ever anticipated. Smith has demonstrated that he understood exactly what Trump would try to do, and he prepared accordingly. Smith completed his investigation, compiled his evidence, and filed his court documents before Trump could make good on his threats. And now, even if Trump moves to fire Smith, even if Trump removes him from office tomorrow, the damage is already done. The filings are already in the system. The allegations are already on the public record. The demand for Trump's testimony is already being considered by federal judges who will decide whether a sitting president can be compelled to testify about his own criminal conspiracy.
That was Special Counsel Jack Smith. We knew he wasn't going to take questions, even though one eager reporter attempted there. Speaking at the Justice Department, talking about the federal charges facing former President Donald Trump and one of his aides. The indictment released this afternoon detailing 37 charges facing Mr. Trump, including the willful retention of national defense information and obstruction of justice. Let's discuss with my panel. And Laura Coates, let me start with you because I want you to translate for us when Jack Smith says that they are going to pursue a speedy trial pursuant to all the rights that the accused has. What does that mean? How soon might this trial begin?
Well, he obviously is aware that the Department of Justice has a policy. They don't want to do anything that might interfere with an election. We know we are 500 some days away from the presidential election.
And 2 months from the first debate.
And 2 months from the first debate. And of course, primaries ahead of that and after that as well. He's aware of that. And the talking point is obviously out there. And he tried to undermine the idea of the adherence to the law as a bedrock principle and nothing else was actually the reason to do this. He's aware of that. And so with an eye towards that notion, he is trying to confirm to the people of the United States who are hearing him right now.
This is a constitutional crisis unfolding in real time, and it demands the kind of serious attention that the American people have not always given to Trump's legal entanglements. The question at the heart of Smith's filing is deceptively simple, yet profoundly consequential. Does a sitting president have to answer questions under oath about criminal conduct that occurred while he was in office? Or can he simply refuse and hide behind the presidency as a shield against accountability? Smith's answer is unequivocal and devastating. There is one set of laws in this country, and they apply to everyone, including the President of the United States.
That they are going to do everything that they can. Now, that does not mean that the judge or everyone else in this case will do everything that they can to do this before any of those timelines, because as you can imagine, if, for example, Donald Trump somehow secures the RNC nomination, and if he is able to become the president of the United States yet again and win over the Democratic incumbent, then that would mean that any period would actually toll at that point, because now you can no longer continue to pursue a case against a sitting president based on DOJ guidelines. And so the speed and the timing will both be a friend and a foe of Jack Smith.
And Andy McCabe, let me ask you, as a former FBI official, is it unusual that the Justice Department decided to release the indictment today? And if so, why do you think they did?
Highly unusual. The normal order is the indictment remains sealed until the defendant is presented in court at the arraignment, which we know in this case.
That'll be Tuesday in Miami.
That's right, Tuesday in Miami, about the same time we're at today. So that's how it normally happens. I'm a little bit surprised that they released it early here, simply because I think it would have been in their advantage to be able to say, we followed the normal process with respect to this remarkable defendant.
The filing argues that Trump's campaign to overturn the 2020 election was not official presidential conduct protected by immunity. It was a private political operation designed to subvert the democratic process and keep Trump in power against the will of the voters. And because it was unofficial conduct, Trump can be prosecuted for it, and Trump can be compelled to testify about it. The courts are now going to have to decide whether Smith is right. The specificity of Smith's allegations is what makes this filing so dangerous for Trump and so potentially transformative for American democracy. Smith is not making vague accusations about election irregularities or general complaints about Trump's behavior.
In every possible instance. However, I think that DOJ capitulated in some respect to the enormous pressure that's been put on them by we in the media and some political figures saying, like, this thing is so volatile, people are so interested in it, the American people need to see these facts today. So that's what they did. But this press conference, very clearly, this was like a cover letter, right? There was no substance here. What Jack Smith wants us to do is read the indictment. And he started his comments by saying exactly that. We have one set of laws. Protecting information for national security's sake is incredibly important, and read the indictment. And that's basically all you got.
Dana Bash, a lot of the Republicans out there running for president against Donald Trump, with the exceptions of Chris Christie and Asa Hutchinson, a lot of them running to Donald Trump's defense.
Yeah, you know, and I literally just got a text from a veteran Republican strategist not affiliated with any of the presidential campaigns saying, if a candidate can't make an effective argument that this guy might very well be in jail, I don't know what they can do.
Well, they probably won't. I mean, many of the candidates, I mean, even down to former Vice President Mike Pence, who you were speaking to just a couple of days ago, not wanting to talk about it, really going out of his way today to not discuss the substance of this case. Pence
Smith is presenting a detailed evidentiary case that describes exactly what Trump did, when he did it, who he did it with, and how he went about executing his plan. The filing references recordings of Trump's own voice giving direct orders to find votes, which is the kind of evidence that no amount of spinning can explain away. The filing references documents showing Trump orchestrating the fake elector scheme, creating a paper trail that establishes deliberate, systematic planning rather than impulsive reaction to events. The filing references witness testimony from people who were in the room when Trump was planning to overturn the election, corroborating the documentary evidence and establishing that Trump's efforts were not isolated incidents, but a coordinated campaign. And the filing references communications between Trump and his co-conspirators that demonstrate knowledge, intent, and a shared purpose to defraud the United States. Smith's explicit request that the court compel Trump's testimony is the masterstroke of this legal strategy. Smith is telling the court that the evidence is so strong, the case is so compelling, and the need for Trump's firsthand account is so essential that the court must order him to sit down under oath and explain his conduct. The filing argues that Trump's testimony is necessary to fully understand what happened, to clarify ambiguities in the documentary evidence, and to allow Trump to explain his actions in his own words. But the subtext is devastating. Smith knows that if Trump testifies, he will either incriminate himself by telling the truth or commit perjury by lying. Either way, Trump loses. If Trump refuses to testify, he looks guilty, and the court can draw negative inferences from his refusal. This is the kind of impossible choice that legal strategists dream about, and Smith has executed it with the precision of a master tactician. The timing of this filing is as critical as its content. Trump came back into office believing that his legal problems were behind him, that the Georgia case had been dismissed, that other cases had been paused or eliminated, that he would finally be able to focus on his agenda without the distraction of criminal investigations. But Smith's filing has shattered that illusion completely. Smith has reopened all the legal questions that Trump thought he had escaped, and he has done so in a way that forces immediate judicial attention. Courts cannot ignore a filing of this magnitude. Courts cannot dismiss evidence this detailed. Courts cannot simply wish away a demand for testimony that is backed by such a compelling evidentiary record. Trump is now going to have to respond to Smith's filing while simultaneously trying to govern as president, and that is going to consume his administration from day one. What makes Smith's filing so powerful is the comprehensive nature of the evidence he has assembled. This is not a fishing expedition. This is not a politically motivated attack based on speculation and innuendo. Smith has conducted a thorough investigation that has produced records of Trump's own voice giving direct orders, documents showing Trump orchestrating the fake elector scheme, witness testimony from people who were in the room when Trump was planning to overturn the election, and communications between Trump and his co-conspirators. Each piece of evidence reinforces the others, creating a cumulative case that is difficult to refute. The recordings of Trump's own voice are particularly devastating because they provide direct proof of knowledge and intent. When judges and juries hear Trump discussing how to overturn the election, it becomes nearly impossible for him to claim that he was merely expressing concerns about election integrity or engaging in legitimate political advocacy. The recordings show deliberate planning for illegal activity. The documents showing Trump orchestrating the fake elector scheme established that this was not something that happened spontaneously or through the actions of overzealous subordinates. This was a plan that Trump himself was involved in creating, that he directed others to execute, and that he monitored as it was being implemented. The paper trail creates a narrative of intentional criminal conduct that cannot be dismissed as misunderstanding or incompetence. And the witness testimony from people who were in the room with Trump provides corroboration for all of this, showing that multiple people heard Trump discuss his plans, participated in his efforts, and understood that what they were doing was designed to overturn the legitimate election results. This is the kind of evidence that transforms a circumstantial case into an overwhelming one. The pressure that Smith's filing places on Trump is almost impossible to overstate. Trump is now facing the real possibility that a federal court will order him to testify under oath about criminal conduct that he has been trying to avoid discussing for years. Trump's legal team has been working frantically to develop arguments that would prevent this from happening, but Smith's filing has anticipated and neutralized many of their strongest defenses. The immunity argument that Trump has relied on so heavily has been directly challenged by Smith's claim that Trump's conduct was unofficial and falls outside the scope of presidential immunity. The argument that Trump is too busy with presidential duties to testify has been countered by Smith's reminder that every president has had to deal with legal matters while in office, and the argument that the demand for testimony is politically motivated has been undercut by the overwhelming evidentiary record that Smith has assembled. The courts are now going to have to navigate uncharted constitutional waters as they consider Smith's demand for Trump's testimony. There is no precedent for compelling a sitting president to testify in a criminal case about his own conduct. There is no clear guidance about what immunity means when applied tied to unofficial acts performed while in office. And there is no established procedure for what happens when a president refuses to comply with a court order to testify. The judges who take up this case are going to be making constitutional law in real time, and their decisions are going to shape the relationship between the presidency and the justice system for generations to come. This is not just a legal battle about Trump's specific conduct. This is a battle about the fundamental question of whether presidents are above the law or subject to the same accountability as every other citizen. Smith's filing has also reignited the broader political debate about Trump's conduct and what it means for American democracy. Democrats are seizing on the filing as evidence that Trump engaged in criminal conduct that requires accountability. Democrats are arguing that Smith's evidence shows why Trump needs to be held responsible for his efforts to overturn the election. Democrats are demanding that Trump testify and answer questions about his actions. And some Republicans, particularly those who still believe in the rule of law, are looking at Smith's filing and recognizing that the evidence is serious and substantial. These Republicans are starting to ask themselves difficult questions about what Trump actually did and what the evidence really shows. Some are even beginning to think that maybe Trump does need to answer these allegations under oath. That kind of bipartisan seriousness about the allegations is dangerous for Trump because it means he cannot simply dismiss Smith's filing as a partisan witch hunt. The evidence is real, the allegations are serious, and the demand for testimony is being taken seriously by courts and legislators alike. The depth of the investigation that produced Smith's filing is staggering in its scope and meticulousness. Smith didn't rush to judgment. Smith didn't cut corners. Smith spent months systematically building a case that would withstand any legal challenge. Smith interviewed countless witnesses, some of whom were former allies of Trump who had direct knowledge of the conspiracy. Smith reviewed thousands of documents, many of which had been carefully preserved by individuals who understood that they were witnessing something historically significant. Smith analyzed communications that revealed the inner workings of Trump's operation to overturn the election. And Smith listened to recordings that captured Trump's own voice discussing the illegal activities. The result of this exhaustive investigation is a court filing that leaves almost no room for reasonable doubt about what Trump did and how he did it. This is not the kind of case that depends on the testimony of a single unreliable witness or the interpretation of ambiguous documents. This is a case where multiple independent sources of evidence all point to the same conclusion. The report that Smith compiled from this investigation found probable cause for charges on election conspiracy, which is a significant legal threshold that indicates substantial evidence of criminal activity. The report details Trump's direct orders to find votes, which were not casual suggestions or rhetorical flourishes, but explicit directives to engage in illegal activity. The report documents Trump's role in orchestrating the fake electors scheme, showing that Trump was not merely aware of what was happening, but was actively directing the effort. The report shows Trump's pressure on state officials to change election results, which involved directly contacting governors, secretaries of state, and other officials, and demanding that they ignore their legal duties in favor of Trump's political interests. And the report provides the framework for Smith's new filing, which makes all of this evidence public and demands Trump's testimony about it. The recordings of Trump's own voice are arguably the most devastating element of Smith's evidentiary case because they provide something that documents alone cannot provide. Documents can be forged or misinterpreted. Witness testimony can be impeached or forgotten, but recordings capture a person's actual words in real time, preserving the tone, the inflection, and the context of what was said. When judges and juries hear Trump's voice discussing how to find votes, or how to deploy fake electors, or how to disrupt the certification process, they are hearing something that cannot be dismissed as political spin or journalistic misrepresentation. They are hearing direct evidence of Trump's knowledge and intent. And when the recordings are combined with other evidence, the cumulative effect is overwhelming. Trump can claim that he was taken out of context. Trump can claim that the recordings are misleading. Trump can claim that he was joking or speaking hypothetically. But when judges and juries hear multiple recordings of Trump discussing similar illegal activities, the innocent explanations become increasingly difficult to maintain. The documents that Smith has assembled also represent a powerful evidentiary weapon because they create a paper trail that cannot be disputed or spun away. Documents don't forget. Documents don't exaggerate. Documents show what people actually said and planned at the time they said said and planned it. The emails showing the planning of the fake elector scheme demonstrate that this was a coordinated effort that involved multiple participants working toward a shared goal. The memos showing the strategy reveal that Trump and his allies had a sophisticated understanding of how to exploit the Electoral Count Act and other legal mechanisms. The notes from meetings where Trump discussed what he wanted to happen show that Trump was intimately involved in the planning process. When you have documents that establish a deliberate, systematic plan to create fake electoral certificates and submit them to Congress, you have evidence of fraud and forgery that is difficult to explain away. These documents also prove that Trump was involved in planning the scheme, which undermines any claim that he was merely a passive beneficiary of others' efforts. The witness testimony from people who were in the room with Trump provides the human dimension that documents alone cannot capture. These witnesses can describe the atmosphere of the meetings, the reactions of participants, the way Trump responded when others expressed doubts or concerns. They can testify about what Trump said and did when he thought no one was recording or writing anything down. They can describe the urgency and intensity of Trump's efforts to overturn the election. And they can corroborate each other's accounts, creating a consistent narrative that is difficult to impeach. When multiple witnesses give consistent testimony about the same events, when they describe the same conversations, when they recount the same directives from Trump, the evidence becomes overwhelming. A defense lawyer can try to impeach one witness. But when you have multiple witnesses saying the same things, corroborating each other, all describing Trump's deliberate conduct, defending against that testimony becomes nearly impossible. The witnesses are not political opponents or disgruntled former employees. They are people who were inside Trump's inner circle during the critical period after the election, and their testimony is central to establishing the criminal conspiracy. The pressure on state officials that Smith has documented also represents a serious federal crime. The filing details how Trump directly contacted governors, secretaries of state, and election officials and asked them to find additional votes for him. Trump apparently asked them to overturn their state's election results, which is a direct request to ignore the will of the voters. Trump apparently pressured them to act contrary to their official duties, which is a violation of federal law. This was not one expression of concern about election integrity. This was a systematic campaign to get elected officials to ignore the will of the voters and change election results in Trump's favor. This is a conspiracy to defraud the United States, which is a federal crime that carries serious penalties. And Smith has documentation of the entire conspiracy, including emails, phone records, and witness testimony that establish the scope and duration of Trump's efforts. The communications between Trump and Vice President Pence that Smith has documented are particularly relevant because they show Trump pressuring the vice president to do something that was clearly outside his legal authority. Trump apparently asked Pence to reject the state certifications when Congress was counting electoral votes on January 6th. Trump apparently believed that Pence had the authority to reject state certifications and declare Trump the winner, which was a fundamental misunderstanding of the law. The Electoral Count Act does not give the vice president that authority. Pence was required to count the electoral votes as certified by the states, not to reject them for political reasons. Trump's attempts to pressure Pence to reject state certifications were illegal attempts to overturn the election, and Smith's filing documents these communications in detail. The filing shows Trump's knowledge that what he was asking Pence to do was outside Pence's legal authority, but Trump was asking him to do it anyway. This is evidence of criminal intent. The immunity argument that Trump has been relying on as his primary defense has been systematically dismantled by Smith's filing. Trump has been arguing that everything he did as president is protected by presidential immunity because he did it in his official capacity. But Smith's filing argues that Trump's campaign to overturn the election was not done in his official capacity as president. Trump was doing these things as a candidate trying to win a presidential election. Trump was doing these things as a politician trying to maintain power. Trump was not doing these things as president performing official presidential duties. So immunity doesn't apply. This argument is legally sophisticated because it tries to carve out space for prosecuting Trump even though Trump was president at the time he engaged in the conduct. The filing specifically mentions communications with Vice President Pence, the alternate slate scheme, and the pressure on state officials, arguing that all of these were unofficial acts done in Trump's capacity as a private citizen engaged in a political campaign, not official presidential acts done in his official capacity. If courts agree with Smith's argument, then Trump's immunity shield collapses. Then Trump can be prosecuted. Then Trump can be compelled to testify. That's a massive legal blow to Trump because the immunity claim has been his primary defense against all the criminal allegations. The legal landscape shifts dramatically if immunity is removed, and Trump becomes just another criminal defendant who can be prosecuted and punished like anyone else. Trump's lawyers are going to fight this argument with everything they have, but Smith's filing has laid out a compelling case that the courts are going to have to seriously consider. The question of what constitutes official versus unofficial presidential conduct is one that courts have been grappling with for decades, and Smith's filing provides a detailed framework for making that distinction in Trump's case. Smith filed all his documents before Trump could fire him, ensuring the allegations are permanently on the record, and courts are already considering whether to compel Trump's testimony. Trump can fire Smith, but he can't undo the filings or make the evidence disappear. The bipartisan calls for accountability, including from some Republicans who recognize the evidence is serious, undermine Trump's ability to dismiss the allegations as a partisan witch hunt and make his situation increasingly perilous. The broader legal implications of Smith's filing extend far beyond Trump's personal legal exposure. If courts agree with Smith that Trump's unofficial acts fall outside immunity protection, then future presidents will know that they can be prosecuted for political conduct even if they were president at the time they engaged in the conduct. That's a major limitation on presidential immunity and a major expansion of the court's ability to prosecute presidents for criminal conduct. It could reshape presidential power going forward and establish a precedent that every future president will have to consider when deciding how to behave. All of these legal questions about immunity and presidential power are being litigated in real time as Trump sits in the Oval Office, and the outcomes of these cases will determine the scope of presidential power for generations to come. The demand for Trump's testimony is going to force Trump into an impossible choice that will define his presidency and his legacy. Trump either has to testify under oath and risk incriminating himself, or refuse to testify and look guilty. There's no middle ground, no way for Trump to avoid the choice. Trump can try to delay the proceedings, but courts are likely to move quickly, given the seriousness of the allegations. Trump can try to appeal the demand for testimony, but appeals take time, and the evidence is already in the system. Trump can try to get Congress to protect him, but the evidence is so compelling that even some Republicans are starting to question his conduct. Ultimately, if courts order Trump's testimony, Trump has to either comply or face contempt charges. Either way, Trump loses. If Trump testifies and admits to the criminal conduct, he has incriminated himself and given prosecutors evidence to use against him in court. If Trump refuses to testify, he looks guilty, and the court can assume that his testimony would be damaging. The only way Trump avoids this trap is if courts reject Smith's demand for testimony. But given how strong Smith's filing is and how much evidence Smith has compiled, the likelihood that courts are going to reject the demand for testimony is low. Trump is essentially trapped between two bad options, and that is exactly where Smith wants him. The immediate future is going to be dominated by this legal battle as courts schedule briefing on Smith's filing and the parties submit written arguments. Trump's lawyers are going to argue that Trump shouldn't have to testify, that presidential immunity protects him, and that the demand for testimony is unconstitutional. Smith's team is going to argue that the evidence supports criminal charges, that Trump's conduct was unofficial and outside immunity protection, and that Trump's testimony is essential to the case. Judges are going to read these briefs and understand the full scope of the legal dispute before scheduling oral arguments where both sides will present their cases in person. These oral arguments are going to be intense because the stakes are so high, and they are going to be covered extensively by the media as judges probe the legal arguments and try to understand whether Trump's conduct was official or unofficial. The judges who hear this case are going to make constitutional law in real time. time, and their decisions will determine whether Trump is ordered to testify. If judges rule that Trump's conduct was unofficial and outside immunity protection, they are going to order his testimony. If judges rule in Trump's favor, they are going to dismiss Smith's demand for testimony. But given how strong Smith's filing is and how much evidence Smith has presented, judges are more likely to rule in Smith's favor, meaning that Trump is probably going to be ordered to testify. And then Trump is going to face the choice of complying or refusing. If Trump refuses, he can face contempt charges. If Trump complies, he has to testify under oath. Congress is also going to become involved in this dispute as the political and legal pressure intensifies. Congress might demand that Trump cooperate with Smith's investigation, hold hearings about Trump's efforts to overturn the election, or use Smith's evidence as a basis for impeachment proceedings. The demand for Trump's testimony is going to force Congress to confront the question of whether Trump engaged in criminal conduct to overturn the election, and Congress is going to have to decide whether to act on that evidence or ignore it. This is going to create enormous pressure on Republican members of Congress who have been protecting Trump from accountability, forcing them to take public positions on whether the president should be compelled to testify about his criminal conduct. Jack Smith's filing, demanding Trump's sworn testimony and documenting an unprecedented criminal effort to subvert the 2020 election, has escalated Trump's legal nightmare to its most dangerous level yet. If courts compel Trump's testimony, he will become the first sitting president ever forced to testify in a criminal case, forcing an unprecedented confrontation between the presidency and the justice system. The outcome will determine whether the rule of law applies to everyone, including presidents, and will shape American democracy for generations.